Hello. This is U.S. Immigration Attorney Sharifa Tharpe. I am here live to take your U.S. immigration related questions. So go ahead and put your questions in the comments, and I have a great topic for you. So today I want to talk about the extreme hardship waiver. And I particularly want to explain what that extreme hardship aspect of the waiver means. Now, in immigration, there are a number of waivers available. Waivers are like forgiveness. It's a request to ask for forgiveness for past violations, immigration violations. And it is, many of them are based on extreme hardship. Thanks for the love, by the way. Extreme hardship of a qualifying relative, and in some cases, your own extreme hardship as the immigrant. And I want to explain what exactly that means. Now, when there are immigration violations, such as maybe you've had a past arrest or a conviction, maybe you've had past immigration fraud or misrepresentation, maybe you're here without status and you're trying to fix your situation by applying for the provisional unlawful presence waiver or for the unlawful presence waiver if you're outside of the US. And these, the waivers and these types of violations, they can render you inadmissible, meaning you're not able to be approved for a visa or for entry into the United States for your permanent residence. And that is where the visa is going to play a very important role in getting you your situation fixed and for you to gain status here. Hi there, Shauna. It's nice to see you, and I'm so glad that you could join me. Go ahead, put your questions in the comments. I am here to answer your immigration questions as well. It does not have to be related to the particular topic I'm talking about. So go ahead and put those questions in the comments. Now, with this waiver, you usually have to have a qualifying relative who can help you to qualify for the waiver. Now, qualifying relatives is going to depend on the type of waiver, the type of underlying immigration violation that has rendered you inadmissible. So, for example, with misrepresentation and unlawful presence, you'll need to have a U.S. citizen or legal permanent resident, spouse, or parent who will experience extreme hardship if you do not get admission into the United States. In other words, you don't get the green card. If you don't get the green card, what kinds of devastating consequences will happen in their own life? And so that is where extreme hardship fits into the whole waiver process. In most cases, when you're dealing with you can only qualify based on another qualifying relative, U.S. citizen or legal permanent resident. You're going to make the arguments and, of course, show evidence of the extreme hardship of your relative. It's not based on your extreme hardship, unless, of course, you're applying based on VAWA, the T visa, or the U visa. So that's very important to understand, because if you just make arguments for yourself and you don't really show the important arguments based on the extreme hardship of your relative, that's where you could very well get a denial. Now, I'm going to give some examples of extreme hardships. So extreme hardships is more than the usual consequences of being separated as a family or being denied. So if you have to go back home, if your relative has to move back to the country with you and they're gonna lose their job, they're gonna face economic consequences, the quality of life may not be the better than the US. These are the common types of consequences that anybody experiences when they have to get up and leave their life in the United States. And that is not going to be enough to qualify for this waiver. Now, what the immigration officer has to do is they have to look at first, does any one of those devastating consequences to your US citizen or legal permanent resident relative, do any one of those qualify as an extreme hardship? So, for instance, maybe your relative has special needs. Maybe your relative is facing a chronic medical condition where they need the care in the United States. At that point, that is definitely going to be on the officer's radar as an extreme hardship. They're also supposed to look, if say they don't find something that strikes them as an extreme hardship on the first review, what they are supposed to do is look at whether altogether all the effects of you not being able to get permanent residence will result in extreme hardship. So they're supposed to look for a cumulative effect of all these devastating things happening to create that elevated level of hardship. So for instance, if your relative was sick, they needed care in the United States, but yet if they go to the country, they're not going to get the quality of care that they need because the medical system is not as good as the United States. And then they're going to lose their job. They're going to lose their insurance if that relative has to move to your country with you. They're going to be facing cultural and social effects. They may need other services along with the medical care. They may need to get Social Security or disability while they're seeking care for their medical condition, and that may not be available in the country. So as you can see, just based on your relative having the medical condition, and then if your relative needs to move to the country, so for example, if you have a resident or citizen spouse that needs to move to your country with you because you can't get the green card, then they won't get the medical care, the level of medical care they need. Then they won't get their disability while they're seeking medical care, and they won't gain access to other good resources that may be in the United States but not in the country. So as you can see, that is an example of where there would be a good argument for an extreme hardship to your relative. So I'm going to stop here to answer some questions. Hi there, Finn's mommy. So nice to see you. Absolutely not. So Finn's mommy, I'm just answering disability. Getting disability will not affect a VAWA case. And your child is a US citizen and they're entitled to get those kinds of benefits. So that is fine. Okay, so awesome 4904. I'm talking about the waiver process in immigration. The waiver and what's required for a waiver. The waiver is a way to ask for forgiveness for past immigration violations. And so I'm explaining what it's going to take to be able to submit a good waiver application based on the extreme hardships of a relative, a US citizen or legal permanent resident relative that qualifies. So you just received your 6-month extension letter for prima facie. Does it usually take this long? So, everything is backlogged. So I'm sure you're not alone, but just check on your case. If you have any concerns, that's where you need to get legal advice. I've been waiting for the interview for over a year now. Yes, it is backlogged. And unfortunately, that's a reality that we have to live with in immigration. Let's see. I married to an LPR. I filed for VAWA in November 2021. How long to have to wait for my I-765 and I-131 to be approved? When will I get a notice to do my fingerprint? So the fingerprint notice can come at any time. It could come a few weeks after, or it could come even a few months. Right now, I'm seeing an average of about 2 months after you filed. Keep in mind, I'm not your attorney and I don't know your case. So I wouldn't be able to tell you in specific when to expect the biometrics notice. Now with the I-765 and the I-131, once again, this is estimates based on my own experience, but they are now taking 9 months to a year to issue the work permits and the travel document. All right, so let's see. So my child is born in the U.S. She has to, does she have to live there? I'm the mother and I'm a green card holder. No, so your U.S. citizen child, as long as she is a U.S. citizen, U.S. citizens in general don't have to live in the United States if they don't want to, but you should check on the immigration process in the country that your child will be staying in, because for example, like Jamaica, and I'm pretty sure a number of countries, they do have a limit on when someone can be in the country, and they have to apply to get some sort of stay or residence, same as a green card holder would here. Okay, so they keep sending me 60 days letter about 6 times. So 592G1, I wouldn't be able to tell you what that means, but they are issuing duplicates, but just check on your case. That's the best you can do, because I wouldn't be able to advise on the specific procedural issues in your case just because I'm not your attorney. So 592, so it says you're in line for the interview but not getting it. Yep, because they are backlogged. Why is it so hard for the green card? It is, I don't know if you mean the length of time or the requirements. If you do qualify for permanent residence, I wouldn't say it's a matter of it being hard, but it's a matter of getting the right help to get you through the process. It may feel hard, may feel overwhelming because you're not getting the right help. So Miguel, that's where it's very important to schedule a consultation and get the help you need to get you through the process, the right process. How long does it take if someone is doing a refiling when you're already in the system? I wouldn't have that information. I know that they are redoing the biometrics, and that can speed things up a bit. You wouldn't have to do the biometrics if you're already in the system. So do you apply for adjustment of status after you've been granted VAWA or alongside the application? Thanks so much for the rose. So in the case where you have a current immigration, so a current priority date, and spouses of U.S. citizens have a current priority date, they're able to apply for adjustment of status and the work permit all at once with the VAWA petition. So everything at once. If you're right now, spouses of green card holders and spouses of U.S. citizens can apply for all of those at one time because both are current. So they can apply for the adjustment of status, the work permit, the travel document, and the VAWA petition. Okay, so Arifa, so you're not a green card holder. Okay, so your U.S. citizen child has the rights of a U.S. citizen, and they are able to live in another country, but you want to make sure that you also follow up on the side of the country that you're going to with your child to make sure that they will give her permission to or him or her permission to live there. If you were denied before, can you get married and apply again? That may be a possibility, but Casey, that's anything that has to do with a denial. If you have been denied, you need to get legal help at this point. You could, if you're denied and then you apply again, you could be making the same mistake twice. You want to make sure that you understand the reason for the denial and see if you should be applying or if there's a better way, or if you can appeal it. So get legal advice, Casey. Make sure you do that. What can I do if I am done my interview over 120 days, but still no decision made by the USCIS? So there are tools that you could use to see if they can speed it up. Now, do they and what happened after the interview? So there is because the interview is not necessarily the end of the process. It's still a part of the process. And so you can do a case inquiry, you can contact your local congressperson to see if they can intervene, but it's going to come down to your circumstances here, whether you submitted a request, if you submitted a response to the request for evidence, then at that point you would be able to put in a case inquiry if it's over that time. But I don't know what your situation is, and that's where it's important to get legal advice. How long is the process of bringing a fiance to the US? So it's taking over a year now. You could be expecting around 18 months for the K1. And it comes down to the embassy and how they're prioritizing the K1s as well. How long does the TPS take? So it's going to come down to your particular case and the service center. But you could, right now, and everything is backlogged, you could be looking at anywhere from 6 to 8 months. A friend filed 2 years ago for her divorce, son and his kids. He got back the confirmation letter. So I'm not sure what this is, Walker. This definitely make sure that your friend gets legal advice, because I'm not sure what the confirmation letter is. I'm not a divorce attorney, and so I wouldn't be able to assist with the divorce. I am a U.S. immigration attorney. But if this is related to immigration, they should schedule a consultation. You can go to the link in the profile to schedule the appointment. And once you click on the link in the profile, it's going to give you all the options to get in touch and schedule your appointment. If I want to bring my fiance to the US and I'm not 21, to do the process in my own cant my mom help. So if you're doing a fiance visa, your mom would not be able to help. But if you're referring to the affidavit of support, that may be where your mom could step in, but you would not be able to. And keep in mind, though, when it comes on to the marriage-based process, there really isn't any age limit for the marriage-based process. So an 18-year-old could file for their spouse to come to the United States. So you wouldn't necessarily, as long as it's legal in the country. So if in the US it's legal, and in the other countries legal, wherever you get married, you can go ahead and do that, as long as the country where you get married recognizes that as a legal marriage. And in that case, that's where your mom may come in. Your mom may need to sign off on approving or give consent for you to get married, depending on how old you are. So what happens if you're not able to get a copy of your birth certificate for the VAWA application? So when it comes on to these particular documents, I don't really get into the documents and list of documents. This is something that I do with my clients as we're going through the process, but there may be alternatives here. When it comes on to presenting identifying documents. So it may not necessarily be something that stops you from getting the benefit, or applying at least. Sometimes what can happen is, if you apply, because it may be an urgent situation, they would send a request for evidence to get the birth certificate. However, when it comes on to documents, we look at each case by case, to determine whether it's essential, whether there are alternatives that can be used instead of those documents. And there are alternatives. When it comes to onto the birth certificate, there are specific alternatives, but that's where we would have to work with our clients to determine what other documents are available. And if not, then and that's called secondary evidence. So the birth certificate is considered primary evidence, but there's also secondary evidence that can be provided in the place of a birth certificate. So how long is the waiting process for a U.S. visa now? It depends on the embassy. Vibes Cartel Vine, it's nice to see you. What's next? What's next if you send your request to the immigration? So they'll usually have an officer contact you and discuss what's going on in your case. Good afternoon. How do I get my newborn baby added to the case? So at the NVC stage, you'll have to notify the NVC that you have your baby. But it depends too. There are regulations in place that dictate how to handle a situation where you're coming in with your baby, and it depends on at what point in the process you are in. Usually at the NVC stage, that's the National Visa Center stage, it's at that point you may be able to add your baby, but I don't know what stage you're at. That's where it's very important to get legal advice, especially when it comes on to a change like this in your application. Because remember, I'm not your attorney and I haven't reviewed your case. So it's important to get that personalized legal advice. You can do that by going to the link in the profile. I received my package like a year now and still waiting on an appointment date. I live in Guyana. Same. You're not alone. This is happening across the board. It really is at crisis level right now where people are waiting over a year for their interviews. So it's just the backlog. Just make sure there's nothing that they're waiting on from you. And then if you need further assistance or something comes up, you can always schedule a consultation. What's next if you send your RFE to the immigration? Then it depends on what the nature of the RFE is. They may just continue processing your case, or they will send you a decision if you're at that point. Can I live in the US? How my child is a citizen? Unfortunately, having a child, a US citizen child alone isn't going to qualify you for residence in the United States. Your child has to be 21 and up to be able to apply for you. If someone's visa is revoked, can they reapply again for a visa? That may be possible, but it comes down to the reason for the revocation. Was there an immigration violation? Was there any situation that rendered you inadmissible? If they revoked it, they probably did it for a reason, and you're probably gonna have to show that whatever reason, if you're not inadmissible, you'll have to show them why you qualify if you're gonna reapply. So it really comes down to why in order to determine what's next. I've been to the embassy 3 times. Each time I go, they keep asking about my mom. So I wouldn't be able to tell you that unless I know what the situation is. I don't know what could have happened with your mom, but that's where you should get legal advice and representation. So SS Orlando, you should get individual legal advice because if you have your newborn baby and you're at the NVC stage, you want to make sure that procedurally you do everything correctly so your baby is covered. So go ahead and you can schedule an appointment if you really want to make sure. And my rule here is that when you're not sure, get legal advice before you do anything. All right, that's going to be it for me today. I will be back tomorrow at 4 p.m. Eastern time. So you can look out for me, hop on and ask your questions. Thanks so much for all your great questions. I appreciate it. I will be back tomorrow, and you can also look out for the videos that I post on Instagram. I'm going over to Instagram now, actually. So if you want to follow up and continue to ask your questions, you can go to The Immigration Attorney, same as here on YouTube, same as on TikTok. So hop on there and I will be available to continue to answer your questions there. In the meantime, I'll see you tomorrow or I'll speak with you in a consultation. Have a great one.